righteousness and truth, grant to our Queen and to her government, to members of the Legislative Assembly, and to all in positions of responsibility, the guidance of your Spirit. May they never lead the province wrongly through love of power, desire to praise, or unworthy ideas, but laying aside all private interest and prejudice, keep in mind their responsibility to seek to improve the condition of all. Amen. Please be seated. Orders of the day, orders du jour.
Orders for third reading, Bill 3, Mobile Home Sites Tenancies Amendment Act 2020. The Honourable Mr. Glubish.
The Honourable the Minister of Service, Alberta.
Thank you, Mr. Speaker. I rise today to speak on and move third reading of Bill 3, the Mobile Home Sites Tenancies Amendment Act 2020. Mr. Speaker, as I've said before, and as we've discussed here a lot over the last while, this bill will broaden the dispute resolution options for both landlords and tenants of mobile home sites by extending the residential tenancy dispute resolution service to address mobile home site tenancy issues. The access to the RTDRS being provided by our government through this bill is an answer to ongoing requests from residents of mobile homes communities, but also from their landlords. And mobile home community residents and landlords have been required to resolve their disputes in the courts, which is a more costly avenue and which takes a longer time to be heard before receiving a ruling. While they've been required to go through the courts, landlords and tenants of apartments, condos, and traditional houses have had the benefit of bringing their disputes to the RTDRS instead. The amendments proposed in this legislation will change that, Mr. Speaker, and bring all landlords and tenants in Alberta in line with each other by opening up the RTDRS to those in mobile home communities. I believe that these amendments will benefit Albertans, Mr. Speaker, by lowering the cost required to resolve some mobile home site disputes, enabling a less formal process which is more accessible, and diverting cases from the courts that would be better heard elsewhere. We've made it clear, Mr. Speaker, that there are still some cases that will need to be heard by the courts, but with the passage of Bill 3, the rules will be the same for landlords and tenants, regardless of which type of dwelling they live in. Whether someone lives in an apartment, a condo, a traditional house, or a mobile home community, disputes over infrastructure and those involving complex legal issues, as well as those where the claims are greater than $50,000, will still be heard by the courts. That is not changing. The real difference here, Mr. Speaker, is that landlords and tenants can bring their disputes around rent payments, breaches of legislation or rental agreement, improper evictions, or unauthorized entrance of the premises by the landlord to the quasi-judicial RTDRS. This is a big win, Mr. Speaker, and will lead, I think, to better landlord-tenant relationships as a whole in mobile home communities. In an earlier stage of this debate, I quoted a few times from Ms. Brenda Neville, a resident from a mobile home community in Parkland Village. She's got great insight on this, as she lives this every day. And so I thought it would be fitting to quote her one more time as we wrap up debate on this very important bill. And so she said, and I quote, "It's very important to allow community owners like Parkbridge and ourselves as tenants to be able to sit down and have a conversation instead of getting all frustrated at each other and just taking it to court instead," end quote. And those words were echoed by the Vice President of Parkbridge Communities, one of the largest community owners and operators of mobile home communities in Alberta. And they said, and I quote, "We support this move to enable access to dispute resolution services as a way to help all parties clarify and resolve issues of responsibility in manufactured home communities," end quote. So, Mr. Speaker, this seems pretty straightforward. We have tenants and we have landlords who are asking for this. On another note, Mr. Speaker, you've heard us talk about the importance of red tape reduction and the benefits of access to the RTDRS make this bill a strong example of the work that this government is doing to reduce red tape to make life better for Albertans. While he didn't use the words red tape, Edmonton City Councillor Mike Nichols said that this bill, and I quote, "is not just about fairness, this is about making the system more efficient. This is about reducing court costs. This is about allowing the residents a chance to hear their grievances before they have to go through our costly court process. And to be quite frank, that's just all good news all around," end quote. Red tape comes in many forms, and this is an example of a pretty common sense piece of red tape to cut. From the outside looking in, maybe it seems insignificant, but believe me, Mr. Speaker, when I tell you that this little piece of red tape means a lot to residents of mobile home communities. As I mentioned earlier, I started hearing from mobile home residents very early after being asked to serve as Minister of Service Alberta, and that's a big reason why I toured the province last summer to hear from Albertans from mobile home communities all across the province. And that's why I'm acting with this bill to bring this forward. Residents in mobile home communities have been waiting years for this access to the RTDRS, and I look forward to being able to tell them that their wait is finally over. Thank you.
Honourable members, thank you to the Minister for moving third reading of Bill 8. I also believe that the, correction, 13. The 3, 8, 13. Sometimes they're all the same. For clarity's sake, thank you to the Honourable Minister of Service Alberta for moving third reading of Bill 3. The Deputy Government House Leader has a unanimous consent motion, I believe, or unanimous consent. It's my first day.
It's early, sir.
He'd like to ask for unanimous consent for something. The Minister of Justice.
Mr. Speaker, I would request unanimous consent of the Assembly that members be able to sit, speak, and vote from any chair within the Assembly for today's sitting.
The Minister of Justice has requested unanimous consent for members to sit, vote, or speak from any chair in the Assembly for the remainder of the sitting today. I will ask only one question. Is there anyone opposed to the request? Hearing none, unanimous consent is granted. Is there anyone else wishing to speak to third reading? The Honourable, the member for Edmonton Northwest.
Well, thank you, Mr. Speaker, and certainly I can empathize with perhaps getting a slow start to one's full cognitive functions. It's kind of like starting a chainsaw, right? You got to give it a couple of pulls and then away you go. I appreciate the Minister's comments in regards to Bill 3 here in third reading, the Mobile Home Sites Tenancy Amendment Act. Certainly, our side here in the New Democrat official opposition was that we had been advocating and canvassing for this very thing for quite some time. And so it's good to see this in a position where we can move forward potentially on this bill. And the first thing I just want to talk about, though, I guess, by way of introduction again, I want to, on behalf of the official opposition and on behalf of this chamber and all Albertans to express our condolences to the families and to loved ones and friends of now the 112 Albertans that have lost their lives due to the COVID-19 pandemic. Certainly, it is a very disturbing time for all of us, but for those who have lost loved ones, I can only begin to imagine the pain and suffering that you have been enduring. And so on behalf of all of us here in the official opposition, I just wanted to offer our condolences to the family members and friends of the 112 Albertans that have been lost to the pandemic thus far. I would also like to express our appreciation for essential service workers who have been, quite frankly, putting in heroic efforts in regards to ensuring that we continue with essential services in healthcare and food services and police protection and a whole range of things that just don't keep the lights on here in Alberta but help us to remain safe and secure as much as we can be during this very difficult time. And I guess in regards to the mobile home site service issue, I think that by empowering the RTDRS to have hearing cases in a wider context, I think that it's important to make sure that we do so in a timely manner. That's my first comment around this. We did put forward an amendment to to ensure that this comes into effect as soon as possible. Now, that amendment was defeated, but I would suggest that the government would consider that by proclaiming and enacting this bill, once it does pass here as soon as possible, then we can begin to actually see the positive benefits of Bill 3 for people living on mobile home sites, communities, and the landlords that are working with those same communities. I think that the intention originally for bringing this bill back was because we considered it to be something that needed to be done as soon as possible, and so we did make an amendment to that effect. I think it's incumbent upon the government to ensure that this does come into effect as soon as possible. And we know that even during the pandemic, we have a capacity for this RTDRS to have hearings remotely, right? They can still use technology, and I believe that one of my colleagues said that they, in fact, are doing so, having remote capacity. So time is of the essence. The mechanism by which this group can start to have hearings is there, and it's functioning, and we can empower them more fully by the swift implementation of this bill as soon as possible. And so I'm just asking quite emphatically but politely that we do that, and I believe that that would send a good message to, in terms of intention and practice, to all parties affected. We know that making sure that we have a fair application of the law to all different forms of housing here in the province of Alberta is absolutely essential. People need to know that they would be protected by law and protected by due process, regardless of whether they're living in condos or in rental apartments or in mobile home communities or whatever circumstance people happen to be living in. And so to ensure that there is due process and a sense of justice and fair play, I think that this bill will help to achieve that. And in the spirit of this bill as well, I hope that we do employ those same principles to all forms of rental accommodation, of lease agreements and condominium arrangements as well, and to just look to make sure that people have access to due process regardless of where they're living, regardless of their ability to pay, and it is done in a timely manner. We know that the lessons that we've learned from the thus far from the COVID-19 pandemic is that if people are compromised in the place where they live, then all other forms of our ability to provide service, to provide medical service, to provide other forms of social assistance are compromised too. And so when we make laws and rules around evictions, say for example, we need to make sure again, that we are extending support to people past the original amnesty on eviction notices that I think came due here at the beginning of the month. I think it's very important, regardless if someone is living in a mobile home community or if they're living in a rental apartment, for example, that we keep people in place and keep them safe with a roof over their heads and triage the other issues that they might be facing based on that foundational principle, that if someone can be in their home, they can be in a place where they live, and they can feel secure around that thing. Now, this bill can help people in a mobile home community site, potentially, by having a dispute resolution mechanism, but let's take the best practices and the principles that are embedded in Bill 3 and make application to that to people in all forms of accommodation that they might be living in here in the province province of Alberta. Now is not the time to build divisions or to have any differentiation of the application of justice to Albertans. Now is the time for us to take a long, hard look at all of our rules and regulations around accommodation and around rental properties and mobile home communities and however people might be living, and to make sure that people are treated fairly and in a just manner, regardless of their circumstance. We know that sometimes difficult circumstances test all of us, but I think that difficult circumstances all can bring out the very best in who we are as human beings, as community members, and as Albertans. And so I believe that this is a small opportunity for us to reflect on that by building progressive legislation that does provide protection and provide a due process for people in mobile home communities. It's an example of a way by which I believe that we can cast a wider analysis of laws that keep people safe, that keep people to a right to a place to live, and an affordable place to live, and a right to access due process regardless of their ability to pay. And so certainly we did bring forward some amendments the last few days that perhaps could have made things stronger. As I would suggest, good ideas are not exclusive to just amendments or the process that takes place here in this legislature. If it's a good idea, like making sure that this gets proclaimed straight away and it's put into law straight away, then certainly that can happen outside of the amendment process with the judicious and the expeditious application of that by this government once this bill does get passed. And so that's pretty much, I think I've canvassed this bill fairly well, and I certainly appreciate the opportunity to have a few final comments before hopefully each member here this morning does find it acceptable to vote in favor of Bill 3 here this morning. Thank you very much.
Honourable members, is there anyone else wishing to speak to third reading of Bill 3? The Honourable Member for St. Albert has risen.
Thank you, Mr. Speaker. It's my pleasure to rise and speak to Bill 3, Mobile Home Sites Tenancy Amendment Act 2020. Very much like my colleague, I of course support this legislation. I think any sort of protection is important, but I did want to talk a little bit about the amendments that have been proposed during the time that we've been debating this bill, because I think it's really important to summarize some of the things, some of the holes or things that we thought could be better, and to talk about what is the hesitation to make things better. And so, it's interesting that government members repeatedly, will say we want to do the best for Albertans, we want to protect, and we're continuously suggesting ways to make it better. Just like government members, we speak to our constituents. We have spoken to our constituents for years. We have heard about this issue for a very long time and have some suggestions for them. And the one that I want to focus on first is the change, the coming into force date. And so it's my understanding that the government plans to do that in the fall of 2020. Well, I would suggest, Mr. Speaker, and that the fact that we're assembled here in this place during a global pandemic and we're doing our best to meet public health orders to be able to do our jobs, which is great, but I would suggest that if it is so pressing that we all assemble here this morning to discuss this important piece of legislation to protect Albertans, that we would want to do everything in our power to ensure that it comes into force as soon as possible to provide that protection for people as soon as possible. So stands to reason that this amendment makes sense. Why not do everything that we can right now to provide as much protection as possible? So the only stats that I've seen for the number of people that potentially would be impacted by this legislation was available in 2016. And it noted that there are about 48,000 people in Alberta that live in mobile homes. So although it's not a massive number when you compare it to the overall population of the province, I think it's significant. And I think it, again, stands to reason why we're here, We know it's urgent. We want to protect every single person possible. Like my colleague said, preventing eviction or stress about housing is always important, and it's vitally important now. And so I would really question, I hope that there is a member that will stand up and explain to us, Mr. Speaker, why it is that this should wait. If it's so urgent, why should this wait? So it is my understanding. So I did a little bit of, I was curious to see what was going on with the Residential Tenancy Dispute Resolution Service, given that we are all dealing with some quite challenging public health orders because of a global pandemic. And the update that was available on their website sort of led me to believe that they had the capacity to do this. Now, I could be incorrect. I would be happy to hear from any government members that have information otherwise, but posted on their site was an update, and they said that they are conducting all hearings by phone during this pandemic. The RTDRS, which is a mouthful, continues to accept applications through online e-filing services. Again, they have created a platform for people to be able to continue on that process, which is great. They are also, during this period that we're all struggling with we're all trying to meet these public health orders. They're giving priority in the hearing schedule to applications for possession or termination of tenancy agreements. Makes sense. There's also been a very significant change in document service. Again, they have been quite proactive to creating a platform so that they can support all Albertans during this stressful time. Good for them. So we know that using this particular service is an alternative to the courts in resolving landlord-tenant disputes, which is great. I'm sure we could speak for hours about some of the things that we could do to improve that process when people do have to go to court in terms of cost and access and timing and all of those things. But this is a good move. This is a good move that has the potential to stop problems from getting worse, and that is always a good thing. Prevention is always a good thing. I think if we didn't understand that before, we certainly understand it now. We are all doing everything possible to prevent ourselves from making other people sick, if indeed we have an infection, or from getting it ourselves. I think that we understand the value of prevention in terms of further stress and additional problems that we can't even anticipate. So again, I would put to the government members, if indeed this is urgent, we're here during a really challenging time where we are dealing with some really important public health orders. We are doing our best to meet those orders, to be here to debate important legislation. Great. But then I would ask, why is it that we're delaying implementation of this if it's that urgent? So I'm hoping that a government member will shed some light on that particular issue. That would be great. The other issue, the other amendments that I thought, well, they were all actually quite good. The removing of the $50,000 cap for cases to be heard in the dispute resolution service. Obviously, the change that coming into force date. The waiving of fees. I think we've talked at length about that. There are a number of other ones. But I just wanted to backtrack a little bit. And, I was talking about preventing future problems in terms of possible eviction or even stress about, for those of you, moving a mobile home, I imagine, is an undertaking that is quite expensive and stressful, particularly if the home is older. I don't know how a home like that would manage being moved after years and years of being on the same place. I'm sure it's possible. I'm sure it's costly. I know in one of my previous jobs, we actually had someone donate a house to us, and then we purchased a piece of land and moved this older home, and not only was it incredibly expensive, but it was also expensive to build a foundation to move the house on. So I imagine there's a lot of cost. So anything that we can do to prevent stress, to prevent eviction, and to save Albertans time and effort right now would be important. And I would like to say a little bit to touch on, although there's only, according to stats in 2016, although there's only like 48,000 Albertans that potentially live in mobile homes, there's still vitally important. And I think if you look at the continuum of housing, that it's actually an important piece for home ownership. Now, certainly, and I'm not talking about homeless supports or homelessness and affordable housing, accessible housing that is perhaps supported by government or other programs. I'm talking about home ownership. And home ownership is, I think, a goal for many Albertans. For most of us, it is likely something that we're comfortable with, that we've had access to, or we own our own homes. But a lot of Albertans do not, and that is one of the big life goals: is home ownership. And owning a home, like a mobile home, which includes some rent payments about lots, is an important step for people. I know a number of people. I always go back to this, but I know a number of people with disabilities, and not necessarily a physical disability, because accessibility of a mobile home, if it's older, is quite a bit more challenging. Excuse me. But owning a mobile home is a reality for some people with disabilities that have saved and worked hard and perhaps, bought it with somebody that they live with. Some families certainly have, or some individuals with disabilities have families that are able to support them to buy a home. That is not the case for everybody. And as you know, people with disabilities are unemployed far more frequently than non-disabled peers and tend to earn not very much money. So home ownership is important, and owning a mobile home is a way to make that happen, or a manufactured home. So I think that it is important that we recognize that home ownership is important, and this particular legislation is obviously important so that we provide people a mechanism to resolve disputes, very serious disputes, sometimes very expensive disputes, in a way that is affordable and accessible. Sounds to me that even during this very difficult time, the RTD, the Residential Tenancy Dispute Resolution Service, is open and able to deal with issues as they arise. So again, to the government, it would be very nice to hear a little bit more about that. Again, sorry, I'm just going to go back. One of the things I did want to reference quickly is earlier, or actually last month, I believe it was, I'm just checking the date here, April 6th, I believe it was, a letter was sent from our caucus for the opposition critic that was tasked with this particular piece of legislation. And I really appreciated that the letter talked about the support for this piece of legislation, but then talked about why these amendments were so important, and then gave some information as to how to achieve that, or how it would positively impact Albertans. And I would just like to say, some of us have been in this place for several years, and some of us on the other side, and we were able to hear arguments from the opposition for many, many hours, for years. And one of the things that I did hear repeatedly, and that did stick with me, is that the job of the opposition is to look at legislation, not just to oppose, but to do what we can to make things better. And I have found a pattern that I think that we should be changing, or look at changing, is that no matter what we propose in terms of amendment, we hear the same thing. Well, no, that's not true. No, that's not necessary. No, we don't need to do that. And I would submit that you don't have all the answers. And so sometimes it is important to listen to other folks with other perspectives to get things right. Doesn't always feel great to admit perhaps you made a mistake, or maybe you overlooked something, or it didn't go far enough, or maybe you didn't think about that. But you know what? A little humility and a little openness to change things to make it better go a long way. So I would submit that these proposition or proposals for amendments really do make it better. The one that I have been focusing, obviously, are the dates. So if we have the capacity to make the changes sooner, why not? Even if you prevent one person from being evicted, or going through the stress of potentially having to go through a process that is not the one proposed in the legislation, I personally would think that's a win. So with that being said, Mr. Speaker, going back to, I am happy to support Bill 3, this piece of legislation. I think anything that we can do to make the process more accessible and affordable and speedy is a good thing. Anytime we can protect homeowners, Albertans, that's a good thing too. And again, for probably the fourth time, I look forward to hearing from the government as to why precisely these amendments were rejected, when indeed they're actually pretty good ideas. They make sense. They would make this piece of legislation better. So thanks, Mr. Speaker. With that, I will take my seat.
Honourable members, Standing Order 29-2A is available if anyone has a brief question or comment for the member of St. Albert. Seeing none, is there anyone else wishing to speak on the third reading of Bill 3? I see the honourable member. It's okay, for Calgary East has risen.
Thank you, Mr. Speaker, for giving me this opportunity to provide my support for Bill 3, the Mobile Home Sites Tenancy Amendment Act of 2020. This is as well a great chance for me to bring in this chamber the concerns of my constituents in Calgary East. Before going into that, I would like to express my sincerest appreciation to the Minister of Service, Alberta, for introducing this amendment into the Mobile Home Sites and Tenancy Act, or MHSTA. It is a needed legislation in this time as we are facing a huge economic impact brought by the COVID-19 pandemic. Both the landowners and the mobile home site tenants will benefit to this amendment to the MHSTA. It will not only benefit the mobile home site residents in my riding, but as well as all other mobile home site residents in Alberta. This is a great help to them in addition to the amendments that was introduced by Bill 11, the Tenancy Statutes Emergency Provisions, prohibiting rent increases and late fees or penalties in today's public health emergency. Mr. Speaker, it was not quite so long ago, that is summer last year, when the minister had reached out to my constituency and sat on a roundtable discussion with mobile home residents of Calgary East. Calgary East is a home of 4 mobile home sites: the Calgary Village, Mountain View, Chateau Estates, and Oasis mobile homes. Each has their own distinct managing organization, and 2 are located beside each other, while the other 2 are almost from end to end of the constituency. As we all know, Mr. Speaker, mobile home ownership is a great option for affordable housing. Before I was elected into public service, I got the chance to talk and interact with residents of mobile homes in Calgary East. I was able to hear their concerns in the community and in their dealings with their everyday life living in mobile homes. The common concerns raised were the sharp climb of rental fees, poor maintenance services coupled with unbearable state of park roads and difficulty to sell their homes. The only option available is to settle disputes in the courts. We shared the same ideas on how to deal with their struggles, but with these just being ideas, Mr. Speaker, nothing will change their situation. Nobody will see the true lighter path for the fast resolution of this disagreement. I was told that they have made efforts to have their concerns heard by the authorities, but to no avail. This common scenario in mobile homes in Alberta has led the Alberta Urban Municipalities Association to support the motion from town of Okotoks in recommending to the provincial government in 2016 to allow mobile homeowners to access the residential tenancy dispute resolution service. In late 2018, the previous member for Calgary East has raised the concerns and the issue to amend the MHSTA. But it appeared that then Minister of Service Alberta was not satisfied with the information or wanting to be released from the obligations, suggesting mobile home owners to reach out to his office or their local municipality. In a separate instance, during the question period on November 22, 2018, and then member of Highwood have raised similar apprehension, but have particularly brought out the response from the Service Alberta minister to the letter sent from the town of Okotoks stating that, quote, I will table it later, and he has no additional information for them, end of the quote. And in the response to both instances, Mr. Speaker, the then minister expressed with similar actuations, stating that, quote, in cases where the provincial government under the current Mobile Home Sites Tenancy Act, or MHSTA, is unable to intervene, these matters can be pursued through courts or local municipalities, end of the quote. This clearly shows the intention of the previous government to ignore legitimate issues and not to make changes or introduce amendments, despite the overwhelming problems the mobile home owners are confronting with great struggle. Not to mention the economic hardships the policies implemented by the previous provincial government and the current federal government, which have brought devastation to mobile home owners. It seemed that they were left to suffer and had to endure the unpleasant situation in a place where they expected to live a prosperous life and could build their family healthier and happy. Accordingly, the situation was one of the factors that made me decide to run for the office. During my door knocking, Mr. Speaker, a lot of mobile home owners had continued to express their disappointment with the then sitting provincial government, which gave the impression that residents of mobile homes are not given significant attention, despite numerous attempts to have their concerns acted upon. This sentiment, Mr. Speaker, did not run away, but instead stayed in my mind and in my heart. I told them that this will be surely acted upon, and I will be fighting for it, and I will have their voices heard. And I was confident that the UCP will definitely address their concerns, which have been continuously ignored by the NDP. That is why, as everybody can see, Albertans did strongly vote for their ejection to serve last April 2019. Several months after elected in office, I was so happy and delighted. Then the Minister of Service of Alberta informed me that he is interested in having a roundtable conversation with my mobile home constituents. The Minister has taken a great step in looking the issues and have wanted to get it directly in person from the very ones that were experiencing it, and for which the previous government did not acted upon except for promise to table it later. It is kind of strange as well, Mr. Speaker, that during the first session of the 30th legislature, the member of Edmonton West Handay stood up in this chamber and had expressed lamentation about the similar state of his constituents, but failed to realize that during their term in the government, they have disregarded the very same action that he had voiced out for the UCP government to act. This is just so sad to hear, Mr. Speaker, that the honourable member now is asking for the UCP government to act immediately on it, but have forgotten that an identical sentiment previously raised before their government was just kept in the shelves. Going back to the roundtable discussion with the minister, my constituents were pleased to hear that they will be able to have an avenue to voice out their struggles, which they did not have for a long period of time. I have reached out with the site owners and managing firm of the mobile home owners to have them get appraised with the issue and to have the opportunity as well to act on any issues that will be easily resolved by them without resorting to the courts. During the roundtable meeting, Mr. Speaker, an overwhelming attendance from Calgary East mobile home constituents were present, new residents and old residents alike. Again, they expressed gladness to have this special opportunity to personally speak with the minister about their difficulties, which they expect to have an end result that is beneficial to both residents and site or lot owners. As I had previously mentioned, Mr. Speaker, they also relate to the minister that they have been facing was brought out to the previous government, but they have not had anything from them. Of course, the mobile home residents understood that this cannot be done in an overnight walk, but nevertheless, they have manifested their joy in looking forward for a better tomorrow. This could not stop the expression of happiness in their hearts in knowing that from there on, the government is making steps in introducing changes that they will have waiting for a long time. It did not end there, Mr. Speaker. Since mobile home sites can be seen throughout the province, the minister had conducted and organized their similar discussion with mobile home residents across Alberta for him to be able to take into consideration every issue that they may have. And I know the minister was well pleased to hear them all. Now, Mr. Speaker, the Bill 3 seeks to include mobile home disputes to be heard and resolved by the Residential Tenancy Dispute Resolution Service, or the RTDRX. Access to the RTDRX, Mr. Speaker, creates the much-needed relief for all mobile home residents. It provides more affordable and alternative avenue for the resolution of issues between the site owner and mobile home owner. It will also unclog our courts from hearing these disputes in the first instance. With the RTDRX access and effective, faster resolutions of disagreements can be experienced by mobile home residents and site owners, which is currently being enjoyed by tenants of apartments and their landlords. It is not a new practice here in Canada, Mr. Speaker. All other provinces have been practicing these inclusion of mobile home sites within their respective tenancy dispute tribunals. I'm very amazed with the immediate response of the minister to the needs of all mobile home residents in Alberta. It may not be able to address all the issues that have been brought forward to him by mobile home site residents in Alberta, but is a big help that will be extended for them which have been rejected by the previous government. To state that they could access the courts or local municipalities is very unsatisfying, and it is as if you are admitting your unwillingness to provide assistance to them when they need it most. The RTDRX will enable their dispute to be resolved in a timely manner, therefore limiting cases of eviction to the mobile home residents or loss of profit to the site owners. Like I said in the beginning, mobile homes are a great selection for affordable housing, and it is much needed option for Albertans who are affected with the ongoing economic instability. Having said that, most people who are living in mobile homes are the ones that are defenseless when it comes to unexpected changes or hikes in their site rents. Moreover, issues like poor park or road conditions and the like may be easily set into an understanding between the parties with the guidance of the RTDRS. Either the landlord or tenant can file applications regarding disputes involving an amount of up to $50,000 to the RTDRS. This is in consonance with the current jurisdictional amount that can be applied to the RTDRX. If we compare to the courts, the maximum amount that can be recoverable in Alberta Provincial Court is $50,000, while a claim involving an amount of $50,000 is heard in the Court of Queen's Bench. This amendment seeks to provide a less formal and less expensive way to settle mobile home site disputes. At the same time, it respects the exclusive authority of the Court of Queen's Bench to receive application as laid out in the MHSTA, particularly Section 59.3 of the proposed amendment, the right to apply to dispute resolution service. If we were to make the jurisdictional amount for mobile home site dispute that can be applied to the RTDRs for more than $50,000, then we are vesting the same jurisdictional amount that the Court of Queen's Bench has original jurisdiction. It could make it more cumbersome for the applicants to file it first to the RTDRX and later on, if not satisfied, appeal it to the Court of Queen's Bench rather than file it directly to the court, and by this, the applicant would have spent more and have waited longer. We have to take note as well that the disputes that we seek to provide to the RTDRX are completely being applied or to be heard by the provincial court civil, often called as the People's Court or the Small Claims Court. Claims involving a large amount of money could be better resolved in the Court of Queen's Bench, as any party can only be represented by a lawyer in the Court of Queen's Bench, while the tenant or landlord can be represented by a non-lawyer in RTDRX. Appeals from the RTDRX orders can be filed at the Court of Queen's Bench, and the same procedure is observed if the dispute has been originally applied to the provincial court. Hence, it is more prudent to respect the jurisdiction amount of claim that had been heard by the courts rather than providing RTDRX a concurrent jurisdiction with the Court of Queen's Bench. Also, the RTDRX application fee is less expensive, which is at $75 compared to court fees, which ranges from $100 to $200. Without this affordable and effective avenue to resolve their grievances, mobile home residents could be left in a situation that is confined with uncertainty. This new development will also make the courts to concentrate in resolving complicated matters, which, as we know, is much more formal process. This is a possibility that the said application fee can be waived if the applicant is in financial hardship. Like the situation of many of my constituents, they have expressed that they are on a break even from month to month and sometimes on a deficit. That is why they cannot afford to pay any rental rate increases that have been imposed drastically by the landowners. In the 2018-2019 report from Service Alberta, Mr. Speaker, RTDRX received 10,754 applications.
Standing Order 29-2A is available. If anyone has a brief question or comment for the honourable member. Seeing none, thank you for your comments. The honourable member for Edmonton Decor on third reading of Bill 3.
Well, thank you, Mr. Speaker. I appreciate the opportunity to add some final thoughts and comments on Bill 3, the Mobile Home Sites Tenancy Amendment Act. I'll start, of course, by thanking the Minister for opening up third reading and providing some final thoughts on this. And my hope is that the Minister will take some of my comments in a positive manner so that as we move forward with this legislation, we provide the best possible outcomes for Albertans, especially for owners of mobile home sites. And so, you know, as I've always said time and time again, I'm always the one that gets hung up on the language, what's in there, what's also potentially lacking. And so while I do feel that Bill 3 is a good piece of legislation, there's some really good solid language contained within that. I do feel a little bit like the small character out of Oliver Twist saying, "Please, sir, may I have some more?" Because it is good. And I think we have the ability to add a few more helpings to be able to make it that much better. And I know the official opposition, Mr. Speaker, brought in several amendments that we thought could take this legislation up to the next level, providing the most best outcomes for those owners. And so one of the comments that I did notice the Minister made in opening up third reading here was around red tape reduction. Of course, I do get the opportunity as the critic of red tape reduction to look at these things. And so as I've seen some of our amendments come forward, by moving from the court system to the disputes resolution, we're absolutely reducing red tape. We're taking up less court time. We're taking up less court resources that can then be dedicated to more important issues within that system. I think when the amendment was rejected, though, we've missed out on an opportunity to be as effective as we possibly can. And certainly I've seen over the course of the past year, you know, a mandate to reduce red tape by this government. I have seen a lot of it being created out of that. And so I think this could have been an opportunity to reduce even more so the red tape that exists here. So hopefully we haven't missed out on an opportunity to be able to make that as efficient as possible. Because as we know, mobile homes is sometimes the only ability for people to gain ownership of their home. It tends to be something that seniors find as a financially viable opportunity rather than getting into a condo system or even just a smaller house. And so, you know, as they say, there's always one out there that unfortunately will spoil it for the rest. And so where we could have potentially kept something out of the court system because the landowner will simply try to outfinance the mobile home owner. And so that's just one example of, maybe some red tape that we could have kept out of the court system and kept within the disputes resolution process. So I hope that the minister will also, I know stated earlier in debates, that resources definitely will be dedicated to this. And I know as we start to get through this pandemic, as we start to get through this economic downturn, and rightfully so, this was expressed by the government to look at its expenses. And I can't help but wonder if, that could unfortunately maybe find itself as one of the things that could end up on the chopping block. And so I know there was a commitment from the minister to make sure that the resources are there, both in funding and within personnel, to make sure that the disputes resolution process can handle the new caseloads. And so I'm hoping that there will be a diligent advocacy on part of the minister to make sure that that's not an area that could be potentially cut back, again, as we come through on the other side of these very difficult times that Albertans and Alberta finds themselves in. The other thing I would hope that I can convince the minister of will be around the coming into force of this legislation. As we've seen throughout this pandemic and the steps that Alberta's had to take to keep Albertans safe, our court system is one that has found itself in a diminished capacity. And so as we come out onto the other side of this and we start to try to catch up on that caseload that was not being able to be heard during this time, again, with the resources being in place, coming into force sooner rather than potentially later will provide mobile home owners the access to the disputes resolution. And so my hope is that the minister will advocate very aggressively to get that moved into force so that those owners have the ability to access that system as soon as possible. So, like I said, a little, I guess, disappointed that the amendments weren't considered for this. Things like removing the $50,000 cap is just the reality of the economy that we're in. It's possible for that $50,000 cap to be reached very, very quickly, depending on the circumstances. So again, thinking back to the red tape, we could have had an opportunity to reduce some of the red tape that could be created. Because once we reach that cap, we'll be saying, oh, well, sorry, that exceeds the mandate here, so now we have to move it there. So again, as the critic for red tape reduction, I think this would have been an opportunity for the government to reduce a piece of red tape that we feel exists within the legislation that could have made it a little bit more efficient. And so hopefully, maybe as we move forward, we see how the system works. Maybe there'll be an opportunity to maybe revisit that in the future. I'm also concerned about fees. Generally speaking, when we have owners of mobile homes, they just simply don't have the finances available to them should it actually have to enter the court system. So again, this could have been a little bit of an opportunity to reduce some red tape that would prevent mobile home owners from being able to access that. And so, again, hopefully, these comments are being taken in the spirit that they are intended, and it is an opportunity to reduce more red tape than what you've already potentially done here. And so I think with that, my other colleagues have said very eloquently the other things that existed within the legislation. I am happy to support this. Again, my hope is that mobile homeowners will be able to access it right away rather than waiting later on. Unfortunately, I have seen some instances where the government seems to, be waiting on something to happen, somebody else to do something, but here's an opportunity to move right ahead on this and give Alberta mobile homeowners timely access to a system that I think will make their lives better and allow fairness to proceed for these owners. So hopefully we will see this get passed and owners will get access to it right away.
Honourable members, Standing Order 29-2A is available if anyone has a brief question or comment for the honourable gentleman. Seeing none, we are on Bill 3, third reading. Would anyone else like to add to the debate this morning? Seeing none, I'm prepared to ask the Minister of Service Alberta to close debate. The Honourable, the Minister of Service Alberta.
Well, thank you, Mr. Speaker, and I would like to just start by thanking everyone on both sides of the House for participating in the debate on this bill, and it sounds as though we're moving towards a unanimous support for this bill. I'm hoping that's where we land, and if so, I just want to thank everyone for their support for this bill. This is a very important step forward to improve life for Albertans who live in mobile home communities. I want to also just thank especially my colleagues, the member from Lethbridge East, the member from West Yellowhead, the member from Calgary East, and the member from Lac St. Anne Parkland, each of which really went above and beyond to organize meetings for me with their constituents from mobile home communities in their community and in their ridings. Those meetings were very helpful to me to inform the work that went into this bill. And I just wanted to recognize them for their contributions to this important piece of legislation. At the end of the day, Mr. Speaker, we've talked about this a lot, but at the end of the day, this is a bill that will open up the Residential Tenancy Dispute Resolution Service, or the RTDRS, to residents and landlords of mobile home communities. At its simplest form, that's what this bill will do. And it's very important. It's something that we've heard ever since I became an MLA, and especially since I became the Minister of Service Alberta. This is something that residents and landlords of mobile home communities have been asking for a very long time. And so I'm very pleased to be finally in the final stages of debate on this bill, and looking forward to making this a reality and making life better for these Albertans. Before I wrap up, I thought it would just be important, to maybe circle back to some of the comments from the members opposite. I respect that they, are trying to make this better, and I know there was some reference made to the letter from the opposition critic on my file, the member from Edmonton West Henday, back on April 6th, that outlined a number of proposed amendments. And I want to assure all members opposite, I did receive and read that letter. I carefully considered that letter. But as the opposition have said many times, the proposed amendments, in their view, were reasonable and practical. Certainly, I would agree they were well-intentioned. But as they well know, I spent a significant amount of time in this chamber during Committee of the Whole as we continued to debate those amendments to outline the reasons why we couldn't and wouldn't support those amendments. And at the end of the day, the reality was that in practice, many of those amendments were impractical. And I'll just speak to one of them as we wrap up here. In terms of the $50,000 cap on matters that can be decided by the RTDRS. I mean, this is important, because I know the opposition has spoken about this a lot, saying, well, we could have just made this better, we could have just increased the cap. Well, here are the facts. The division of powers between Provincial Court and Court of Queen's Bench is based on the Constitution Act and based on the types of decisions being made by each court. And the Provincial Court limit is set at $50,000, which is well above the $5,000 constitutional limit. But we had set that in Alberta in order to reduce the caseload of the superior courts. And but the fact is that increasing the threshold of the RTDRS beyond that of the provincial court would likely result in a constitutional challenge that such authority would interfere with the jurisdiction of the Court of Queen's Bench. So this is the reason why I did not support that amendment, because it doesn't make sense. So this is not a case of the government just saying, we know better, or we don't like your amendments, or we don't like them just because they came from the opposition. This is a case of where the amendment didn't make sense based on the facts. So, I agree that this chamber is an important place for us to debate with one another and to consider feedback from all sides of the House. I did consider the feedback provided by the other side of the House, and I just wanted to make it clear that I was not just outright rejecting amendments simply because they came from the other side. And I hope the members from the other side can, even if they don't like where we landed on this related to their amendments, I hope they felt like I dedicated a significant amount of time to listen to them during Committee of the Whole and to address our response to that in the spirit of debate. So, one of the final things that I will just say is I know there's been a lot of talk from the members opposite about how they've been advocating for this and working on this for a very long time. And certainly, they've been working on this year since I brought this forward, and I want to thank them for the work they've done this year to add to the debate. But I think it's important that we not rewrite history. Let us remember that they were in government for 4 years. They had an opportunity to do this a long time ago, and they didn't. I don't know why. It's also important to remember that they had a private member who wrote a letter to the National Post on November 6, 2018, after having become an independent MLA, having had to leave the government caucus at that time over this issue of mobile homes. And I'll just quote what this former member said. She said, and I quote, "There are issues that are important to folks in my riding that I have been advocating for, that I've been told are not priorities at this time, but that I have also not been allowed to speak about publicly. One of these things is a critical review of the Mobile Home Sites Tenancies Act." And she went on to say, "Every time I bring it up, I am told it's not on the to-do list and that I can't ask questions about it in QP," which we all know is question period. And she closed by saying, "This is a tragedy of epic proportions." That was former member Robin Luff. So I think, I'm grateful for the support of the members opposite on this bill. It is an important bill, and I'm grateful for the attention they've put on this to try and help contribute to the debate. But it is important that we recognize that they had 4 years to focus on this if it really was such a priority. They didn't. And but the past is the past. Here we are now today. We're all working together to get this done. And I'm very proud to be a part of the government caucus that is leading the way to bring this bill forward, to make it a reality for Albertans who live in mobile home communities, to give them access to the RTDRS. This will make their lives better. It's a great step in the right direction. And so with that, Mr. Speaker, I am very pleased to move to close debate. Thank you very much.
Honourable members, the Minister of Service Alberta has moved third reading of Bill 3, the Mobile Home Site Tenancy Amendment Act 2020. Those that are in favour of the motion for third reading, please say aye. Aye. Those that are opposed, please say no. In my opinion, the ayes have it. That motion is carried and so ordered.
Bill 3, Mobile Home Sites Tenancies Amendment Act 2020 is now read a third time. Under Government Bills and Orders for third reading, Bill 8, Protecting Survivors of Human Trafficking Act, the Honourable Mr. Schweitzer.
The Minister of Justice and the Solicitor General.
Thank you, Mr. Speaker. I am pleased to move third reading of Bill 8, the Protecting Survivors of Human Trafficking Act. Human trafficking is a dehumanizing and predatory crime that violates a person's basic human rights and dignity. Traffickers prey upon people of all ages, ethnicities, and genders. They coerce their victims into providing labor or sexual services against their will. Traffickers often use threats and violence against the survivor and their loved ones to trap them in a cycle of exploitation. This crime is also often unconsciously ignored by the general public. Albertans think that human trafficking is something that happens somewhere else, but it happens right here in our home. The truth is that it happens in our communities, and sometimes it's happening at the business or house next door. Reported incidents of this horrible crime have skyrocketed in recent years, and it's time for Alberta to take real action to fight it. I'm proud to stand with a government that refuses to sit idly by and allow this abuse to go unchecked in Alberta. This legislation will strengthen a survivor's ability to get away from this abuse physically, emotionally, and financially. And by passing this legislation, it would allow us to create an annual day of awareness for human trafficking, a standard definition of human trafficking, a standard definition of sexual exploitation, a statutory tort allowing survivors of trafficking to sue their traffickers, a statutory remedy allowing survivors to secure a protection order from the traffickers, and a warrant permitting a police officer entry. This Made in Alberta legislation will strengthen a survivor's ability to get away from this physical, emotional, and financially damaging abuse, and will empower them to hold those who prey upon them accountable. This legislation will also allow us to deliver an important platform commitment and will make us a leader in Canada's approach to protecting and empowering survivors. I expect members on both sides of this House to support this legislation, and I've been thankful for the debate so far. Thank you, Mr. Speaker.
Honourable members, the Minister of Justice, Solicitor General has moved third reading of Bill 8. Is there anyone else that would like to join in the debate this morning? The Honourable Member for Calgary Mountain View.
Thank you, Mr. Speaker, and I think I've certainly spoken to this bill a lot, so I'll keep my comments relatively brief, I think, at this time. We absolutely support this bill. We've had the opportunity now to speak to a number of different stakeholder groups that work in this area, and they have generally expressed support for this bill, so I think that that is a really good reason to be in favor of it. This, again, as I've said before, I think it's worth noting that this is a horrendous crime. It is one which is occurring right now all around us in this province. Many people don't see it or don't hear about it or don't experience it, but like many things that are going on in our society, not everyone is necessarily aware of the crimes that go on around us. So despite the fact that we may not have seen it or interacted with it, it is happening right here and now in Alberta. I think it's worth discussing a little bit. So in Alberta, in terms of trafficking, a little bit over half is usually related in some way to sex trafficking, and then almost half, so not quite half, is related to labor trafficking. And so what that makes it is a complex area because the labor trafficking almost always, not always, but frequently involves individuals who are in the country who are not citizens. And so that makes it a really complicated area of law because the person who is doing the trafficking may remove their passport, therefore removing their ability to return to their home country. They may be here on a temporary work permit, and the problem is that that renders them vulnerable in certain ways because that work permit often only applies to a specific employer. Sometimes it can apply to sort of a class of employers, but often it applies only to a specific employer. And so that means that once the person has arrived here, they're often in a position where if the employer decides to make them work very long hours, work in poor conditions, doesn't pay them what they ought to have been paid or at all, makes them live in terrible conditions. Many of those things are very difficult to remedy because they know that they have hanging over their head that ability of the employer to essentially terminate their employment, and that means that either they're stuck in Canada with no way to support themselves, or they have to go back to the country they came from, and often these individuals are here trying to work to make money to support their families because there's no work available to them where they came from. Now, I'm not saying that those types of work permits are never useful because sometimes, especially with respect to sort of skilled trades, that we have a shortage of those individuals in this country, they certainly make sense. But I think sort of my view has always been that historically, and this is certainly how my family came here, the sort of deal has been you kind of come here and you work very hard and you bring your family. That's how it goes. My grandfather came here, lived at the YMCA, worked a job while building a house to bring his family over. So, and I think that's a pretty common story. So returning to the subject matter, I think at hand, this is a crime that's going on around us, and so that is the reason why it's important to move this legislation forward. I was incredibly pleased to see, though somewhat surprised, that the government actually accepted an amendment from the opposition. So the in-force date on these orders was originally set to be December 31st of this year, so about 8 or 9 months from now, and we have now moved that back, so it comes into force in July. So that's right away, and I think that is incredibly important because this bill was introduced, and we heard over and over again from government members, some with quite a lot of anger, honestly, Mr. Speaker. We heard over and over from them that this needed to go through right away, and so I think our response to that was, this is a problem that's happening right now. But if it's so critical to pass a bill in under 48 hours that we can't even have time to consult with stakeholders to see what their view on the bill is, then perhaps we ought to bring the in-force date back a little bit. And the government has accepted that. So I would like to applaud the minister for that, because we haven't actually seen a lot of that in the 30th legislature here. So that is a very, very good thing. So that being said, this bill is important, it's urgent, stakeholders are supportive. I think certainly our caucus is very supportive of this bill moving forward. I did want to raise a couple of points that I got in my conversations with stakeholders, and those are simply that they're looking for a few extra things. So this bill, when it was announced, was coming with a committee, and that committee has various folks who are working in this area on it, or it's supposed to. The committee itself is not referenced in the bill at all, so that was a bit of a source of concern, because a lot of the answers to a lot of the outstanding questions on this issue have been, well, the committee will deal with that. So the fact that the committee itself is not in the bill, it's not legislatively mandated, is a bit of a concern. I had actually hoped to hear the minister, because we've asked this question repeatedly, hoped to hear the minister respond and tell us who was going to be on the committee, when the committee was going to be called, when the committee would be expected to report back, and at what point, whether the recommendations of that committee would be made public. Because I do think that while this helps, and while this deals very positively with the issue, there are a number of outstanding issues that need to be dealt with. So the work of that committee is going to be critical. This is a really, really positive and good first step, but it is just that, a first step. And so I think we need to know that the recommendations of that committee will be public so that the government can be held accountable. The other two big things had to do with funding both for support agencies and for legal advice, because that sort of earlier digression was about the fact that this is a legally complex area. And so allowing legal advice is really, really important, because people don't necessarily know what rises to the level of human trafficking. And so that's a pretty important step. The other thing that has been asked for by the community is a sort of dedicated secure shelter for individuals, particularly individuals who are victims of sex trafficking, because they're very, very traumatized, and people who are very, very traumatized require a lot of support. Sometimes when you're dealing with trauma, the average sort of everyday things that you and I, the ways in which we behave and interact and respond to one another, become challenging. And so that support and that ability to have a safe place to go is absolutely critical. So those are the asks. I hope that even though we haven't heard directly from the minister on this point, that those things are being considered and that they will come forward in the fullness of time. So I certainly hope we see that. But I do want to reiterate that our caucus, myself and my colleagues, are absolutely supportive of this bill. We're supportive of it moving forward. We're very glad to see that the government has taken these steps, and we're very glad to see even the change in this bill between the platform and now has been significant. It's clear that the government and the minister are listening to the stakeholders out there, which is a really, really good thing. And so I would just like to urge all members to vote in favor of this bill.
Thank you. Is there anyone else wishing to speak to third reading? The honourable member for Edmonton Castle Downs has the call.
Thank you, Mr. Speaker. It's a privilege to rise today to speak to Bill 8, Protecting Survivors of Human Trafficking Act. I believe that this is an essential piece of legislation, and that it's really nice to see that government has accepted our amendment to change the date from July as opposed to December. But like my honourable colleague was talking about, the legislation as it is needs to go a little bit further. I can speak to firsthand experience as a social worker working with many who have been sexually exploited, and knowing that there's a process from identifying that this individual has been sexually exploited to doing the legal action that needs to occur to the final step, perhaps in supporting that individual. And what does that look like? And so while there's been identified that supports are necessary, I would really hope that government is looking at what that looks like. And through the committee that they've established, I agree with the honourable member about making that public, because when we're looking at supporting individuals who have been sexually exploited or human trafficked, it doesn't end at the court process. There's trauma that's occurred, there's healing that needs to occur, and unfortunately, Mr. Speaker, a lot of the bad guys are known to the individual. And so this is someone that they have grown to trust, someone that they sometimes love. And so there's that relationship there through this entire process. And so when we're looking at the importance of healing and not being sexually exploited again, there needs to be strong systems in place. And sometimes that's second stage housing. When we look at those that are exiting human trafficking, they need to have supports. I can speak to some of the youth that I've worked with over the years, and sometimes it takes a few times having them come into the system, working through the Protection of Sexually Exploited Children's Act, through PSECA, and getting them to a place where they believe in themselves and healing that trauma. And it can take years of supports and ongoing assistance and being connected with these individuals. And so I am 100% supportive of this piece of legislation and believe that it is essential and it will save lives. But the trauma's occurred. If we're at this stage in this person's life, they have been exposed, it's been confirmed, they need support and they need resources. And so looking at what that looks like and how we can best transition individuals into a healthy lifestyle and healing some of that trauma. I know when I did my first piece of legislation as a private member, I did the Post-Traumatic Stress Disorder Awareness Day, and talking to individuals who had been exploited, it's likely that someone who has been human trafficked will experience PTSD. And so acknowledging that it's a different kind of treatment when we're looking at this relationship because of the connection with the bad guy. It's not as black and white sometimes as other forces of trauma, other perpetrators aren't known to the individual. And so it takes a special type of intervention and support that's required for these individuals. And just having that understanding and awareness that the legislation is fantastic, but there needs to be the next phase. And how do we support people that are exiting human trafficking? The other piece that I would like to briefly touch on that I've spoken about in this House is the PSECA legislation and how there's different explanations and definitions of what sexual exploitation is. And I would hate to see that there's a loophole, if you will, when we have two pieces of legislation that are in conflict with each other. So I really hope that when government moves forward with this piece of legislation, that they're also looking at the PSECA legislation to ensure that the definitions match, so that when you're working with youth, children, that there isn't some sort of legal loophole that allows the bad guy to get away with this. We need to make sure that everything that we're providing for supports and resources to the police, to children's services, to judges when they're making decisions, is that it's consistent, it makes sense, and the legislation supports each other. So I would really hope that government looks at CAIFIA, the Child Youth Family Enhancement Act, as well as PSECA, and ensures that there's that consistency, that similarity between the two pieces of legislation that are absolutely essential when we're looking at protecting children from being sexually exploited. I think this is a strong message to individuals that have been human trafficked, to those that work tirelessly, day after day, to support and identify, whether it's the police, whether it's social workers, psychologists, psychiatrists, medical health professionals that perhaps come into contact with these individuals. It's an incredible first step, but we're hearing from the community, from stakeholders, from individuals, that there's definitely more that's needed. We need to make sure that people that are being traumatized, being human trafficked, have that transition in place. They have that support. So having some sort of reporting system to what the committee that's being established looks at and recommends would be incredibly helpful. I know many members on this side of the House have background in social work and have firsthand experience of working with individuals that have experienced this kind of trauma. And it would be nice to be able to see some of that and to be able to report to our communities and our stakeholders about what the process has been and where things are at and what the recommendations are. I know personally I'm quite invested in the outcome of this and seeing some of the supports that are going to be available. I think it's an incredible step. And with that, Mr. Speaker, I would like to close my comments and just say I support this piece of legislation going forward. Thank you.
Members, Standing Order 29-2A is available. If anyone has a brief question or comment for the honourable member. Seeing none, is there anyone else wishing to speak to third reading of Bill 8? I appreciate the support from the honourable member from Fort McMurray-Lac-La-Biche, but I think the speaker will determine when the question is going to be called. Or Wood Buffalo, whichever you are. Is there anyone else wishing to speak other than the member of Fort McMurray Wood Buffalo? Seeing none. The Honourable Minister of Justice and the Solicitor General has moved third reading of Bill 8, Protecting Survivors of Human Trafficking Act. All those in favour of third reading, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. That motion is carried and so ordered.
Bill 8, Protecting Survivors of Human Trafficking Act is now read a third time.
I see the Honourable Chief Government Whip has risen.
Mr. Speaker, thank you very much. I know we've made some great progress this morning. I'm sure we'll make some great progress later on this afternoon. I'd like to rise, and I move that the Assembly adjourn until 1:30 p.m. today. Thank you.
Honourable members, having heard the motion as moved by the Chief Government Whip to adjourn the Assembly till 1:30 today, all those in favour, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. That motion is carried and so ordered. The House stands adjourned until 1:30 today.